Hi, my name is Michael Bryant. I'm an attorney. I practice primarily in Lucas County and other surrounding Northwest Ohio counties. I practice primarily juvenile and domestic relations law. Today we're going to talk about temporary orders and permanent orders in a divorce. If you're involved in a divorce in Ohio, the process can be pretty confusing. There are two tracks in a divorce, and people don't often get them confused, don't understand them. First track is the temporary orders track. Not every divorce has temporary orders, but most of them do. Temporary orders are issued by the court to keep the family unit and the money moving while the divorce is pending. Divorces can take many months, more than a year, to become final. The court wants to make sure bills are getting paid and parents are seeing kids during that time. Some things that are typically ordered by the court on a temporary basis are custody of the children and visitation to the non-residential parent, child support, spousal support, who gets to live in the marital home, as well as who pays certain bills. The process in many Ohio counties can also be confusing. In order to get temporary orders, a party must ask for them through an affidavit. The court then makes temporary orders based solely on that affidavit and other paperwork submitted to the court, the pleadings. If the party doesn't think the orders are fair after that, they can request a hearing. It's only then, at that hearing, that they get to submit documents and evidence for the court to actually listen to make temporary orders. The second track is the permanent orders track. These are the final orders that the court will make in a case. It's usually an agreement between a husband and wife, dividing up all the assets, debts, and accounting for custody and parenting time. This is the one that finalizes the termination of the marriage, and this is when the divorce is finally over. Each of these separate tracks have their own hearings and their own types of hearings, and it can get even more confusing if you have two hearings on the same day, one on each track, or if you have hearings on a permanent orders before you have hearings on a temporary orders. Then there are different factors and standards of evidence that the court must consider in each track. For instance, a party may not be entitled to spousal support on a permanent basis, but they may be likely to get an award of spousal support on a temporary basis. Then there's the interplay between the two tracks that isn't written in any law anywhere. Think about the negotiation incentive or the lack thereof. If one party got everything they wanted in the temporary orders, they're probably not going to be willing to negotiate very much on the permanent orders. There are many moving pieces to a divorce, and the process can be confusing and overwhelming. Make sure any attorney you hire knows the process and knows how those processes work in your county. If you aren't already represented by an attorney, you've got questions, you can give me a call. My name is Michael Bryant, 419-243-3922. Again, it's Michael Bryant, 419-243-3922.